Yes, Mr. Drabble. Can I say before we start, first of all, I lost my voice last week and I can't find it still. The second thing is that this is being live streamed. I can't think that any information is going to be spoken in the hearing to identify any of the individuals at the centre of the case, but if everyone can make sure that we don't, there are ways of editing the live streaming, but I think if we all try and avoid identifying anybody as being an individual in the proceedings, then that's the safest way to proceed.
Well, speaking for myself, I don't think there's going to be any need to look in detail at the identity of individuals.
No, I'm bound to say I don't. I haven't hoisted in the name of the individual. I'm using the initials that have been used. Yes.
Please, the court. I appear with from Chris Barnes for the appellant.
Yes.
Lorraine Kavanagh, Queen's Counsel, and Sean Spencer appear for the respondent local authority. Brendan Roach, Queen's Counsel, and Kathleen Hayter appear for the Guardian. The first intervener, the Secretary of State, is represented by Jonathan Ober, Queen's Counsel, and Ruth Kennedy. And Johan Clement appears for the second intervener, Ofsted.
Yes.
I think that covers it. I think
That's a
succeeded in that.
embarrassment of experience and advocacy.
Your court will have seen that this is my appeal from the order of Mr. Justice MacDonald following a grant of permission by the judge himself. We'll turn to the order in a moment because it is in fact helpful to bear in mind the actual terms of the order that he claims, or the other side claims, authorised by the inherent jurisdiction. The appeal concerns the effective amendments to the care planning, placement and care review England regulations 2010. The judge held that the amendments did not prevent the use of the court's inherent jurisdiction to authorise a deprivation of liberty in an unregistered care home. The reasoning in his judgment involves application of the Supreme Court decision in Re T, and the central issue in this appeal is whether that decision can be read across and applied in the way in which the judge applied it in the circumstances that prevail after the amendment. We say that the reasoning of Re T cannot be applied in these circumstances. Put shortly, we say that the amendments render such a placement, that is of a child under 16 in an unregistered care home, is unlawful in a way that was not true in the circumstances of Re T. We'll try to spell out precisely why in more detail in due course. But the court will already have seen that we have two grounds of appeal against the judgment. They're obviously very closely interconnected. The first is that the fact that the underlying placement in which the deprivation of liberty is authorised by the court is unlawful renders the detention in breach of Article 5 as not authorised by law. And the second is that there is an impermissible clash with the statutory scheme.
Yes.
And the two go effectively hand in hand. They're very, very closely related.
Clearly, at the core of the appeal, and indeed I think you've mentioned it twice already, is your submission, and it's an assumption within the appeal, that the amended regulations apply to this placement. This is, as I understand it, an unregistered children's home.
Yes.
And your submission is that that is caught by the amended regulations, and it is now prohibited to place an under 16-year-old in an unregistered children's home.
Yes.
Now, the judge deliberately didn't decide whether an unregistered children's home was or was not within the amendment regulation. So it would seem to me that in order for your appeal to move forward, you need to grapple with that, and we in turn probably need to grapple with it in our judgment in a way that the judge considered he didn't need to.
Yes, I accept that.
What's your understanding of the reason why the judge didn't do that?
I wasn't there, as your lordship
You're
appreciates.
the least likely person.
No one for my client was there, more importantly, as
Yeah.
well as missing me. But I wasn't there. I don't know. I have since been to two further hearings. One a directions hearing following the hand down of this judgment and the grant of permission to appeal to the Court of Appeal, and the other the hearing that led to the judgment on the relevance of the President's guidance.
Yeah.
I don't think there is really a live dispute, as I understand it, that the present placement is in a home that is not registered and is therefore caught by the regulations on my construction of those regulations. And I
think that's
accept that we have to deal with that.
That's the issue.
I was just saying, I'm not convinced I need until lunchtime to put forward this appeal, but there are two central issues. One is the correct construction of Regulation 27 read together with 27A in the amended form. We have 2 or 3 paragraphs dealing with that construction in the skeleton, and I stand by those paragraphs. And in our submission, it's simply not possible, as a matter of language, to read 27 read together with 27A in a way which permits the use of a home that doesn't meet the criteria of a home being registered in 22C6C, I think it is.
Yes.
Got to the
May I ask
place.
one further, before you just, obviously that's the heart of your case.
Yes.
Looking at the young person,
Yes.
the young person is still in this placement. Nothing's changed in the last few days.
Nothing, as I understand it, nothing's changed in the last few days. There were ongoing attempts to proceed with the registration with Ofsted, and others will be yet more up to date than me with that.
So what does your client hope or think should happen to this young person?
We certainly are not asking for an immediate end to the placement. We ask that it should be brought in line with the correct law. But our legal analysis is not quite the answer to your Lordship's question. I understand that.
If your appeal succeeds, what will then follow? The local authority would have to move the child immediately?
No, not immediately. But we accept, and I think say in terms in the skeleton, that there is a potential case of operational necessity arising from Articles 2 and 3 of the Convention. And we submit that the correct analysis is that the regulations fall to be construed in the way in which we say they should be construed. Therefore, on the face of it, a placement by a local authority while the regulations are being applied cannot be authorised under the inherent jurisdiction because the placement is unlawful, and the placement, we say, is a central concept to the working of all the regulations, including the placement plan and so on. If, therefore, you're in Lord Stephen's territory of a operational necessity to prevent a breach of Article 2 or 3, death or whatever, then the regulations fall to be disapplied. It's a disapplication case, which has the practical effect that the local authority has to get on with it, and that I suspect is my client's principal concern. And that is my answer to your Lordship's question. I hope that answers it. But we do say that the present approach of the court below is unsatisfactory as a matter of basic principle because it doesn't grapple on our construction of the regulations.
What is it that your client, as a mother, wants to achieve for her daughter that she thinks she's going to achieve by
She wants
succeeding on
close
this appeal?
supervision of the placement.
Sorry, she wants?
Close supervision of the placement. That was her principal concern. It doesn't, as I understand it now, let's make sure that I'm saying this compatibly with my instructions, she doesn't want the immediate, i.e. in days, termination of the placement. Your lordships will understand it has some distinct geographical advantages apart from anything else.
Well, I've read the account in Mr. Roach's skeleton, and
Yes.
it seems that after a long period where life has not been very satisfactory, putting it the most neutral way for CK, she may have turned a bit of a corner in a positive way. And,
Well, I'm not arguing against that at all.
so that, therefore, my lord asks the question, I ask it as well, as to query why the mother is looking to challenge this arrangement.
Well,
You've answered it.
I've given your lordships and the court the answer. The answer, I mean, that is the answer. I don't disguise the fact that I've been asking myself your lordship's question. Well,
Yes.
I hope unsurprisingly. And the gap between the end results asked for by the Secretary of State, by Mr. Oban, and ourselves is small. He says as a matter of construction, the regulations don't mean what we say they mean, but then asserts that if they do, there is the jurisdiction identified by Lord Stevens.
But the net effect of this will be that if your interpretation is upheld by this court, the squeeze on local authorities, as it were, for operational necessity squeeze, will be even tighter.
Yeah, that.
And local authorities will be under an obligation to do even more than they're doing already to try to meet these extremely difficult cases which we're having from all over the country all the time.
That's precisely the answer that I've been giving to myself, the answer to your lordship's question. Yeah. And I'm not sure that I can really take this point much further, except to say that in the background there is, of course, a potential breach of Article 5. The one we identify in the skeleton and are arguing about this morning is a breach of Article 5 that we say arises from the fact that there is effectively a combined operation, if I can put it loosely like that, between the inherent jurisdiction of the court and the local authority making the placement. If the placement is simply ultra vires, there's no authority for the expenditure of money on the placement. It just doesn't work like that. And we say that therefore that end result, deprivation of liberty in those circumstances, is a breach of Article 5 for that reason. But even if that's wrong, and as the judge says, I think in the last paragraph or so of the practice guidance judgment, there are Strasbourg cases which suggest that which say that a failure to provide sufficient resources to finance the safeguards that the national scheme thinks is necessary for a deprivation of liberty is itself a breach of Article 5.
There isn't an appeal pending, is there, from the practice guidance?
No.
Because I anticipated, the case manager of this appeal, that there might be.
Yes.
As it was clear from the directions we gave. But as it turns out, nothing's...
Yes, I mean, that's probably quite closely related to your lordship's initial question of me. There isn't an appeal by either side, if I can put it.
Or any of the other...
Anybody, there isn't an appeal. There isn't an appeal from either perspective. So one takes it as read effectively that if you're not dealing with the particular problems created by 27 and 27A, then the Métis jurisdiction is available, but has to be exercised in accordance with the President's guidance, so as to, as nearly as may be, replicate the statutory scheme and get it all back into the into a regulated melting point, if I can put it like that.
Right, on we go.
So if I could just make good the promise to invite your lordships and my lady to look at the order.
B41.
go for B42 of the core bundle. And it's paragraph 4. The judge ordered that the court, having concluded by way of the judgment dated the 8th of September 2021, that it retained the jurisdiction to authorise under its inherent jurisdiction the deprivation of liberty under the child of under the age of 16 in a placement in which the restrictions that are the subject of that authorisation will be applied following the implementation of the amendments to the regulations. So the reason for going there is that this order, and as I understand it, other orders of the same sort, operate by authorising the deprivation of liberty in the context of the placement.
Yes.
And we will see that when we come to look at Ray T, the language used by Lady Black and indeed Lord Stevens, and even more so Lady Arden, are aware of the status of the Lady Arden's judgment. It's a theme that runs all the way through.
Insofar as there's a distinction between the justices of the Supreme Court, the majority is with Lord Stevens and Lady Black.
Oh yes, yes, I accept that, and I would accept that Lady Arden goes one stage further down my route, if I can put it like that, for reasons that we'll look at when we come to it. The others don't say that's wrong, as I understand it. And she, I think, expressly is giving additional reasons to those formulated by Lady Black and Lord Stevens.
We'll come to whether there's a contrast.
My submission, nothing turns on this, because one simply identifies.
I think you're right. Having waited 10 months for the judgments to come out, we rather expected it to be more of a standoff between some of the justices, but in fact it sits together, albeit that there's an extended view offered by Lady Arden.
Put very shortly, Lady Arden plainly says that if the use of the premises was criminalised, then the inherent jurisdiction would not be available. Yeah. The other two, or the majority, don't go that far. Yeah. But nor, this is an
they don't say Lady Arden was wrong.
No, they don't. Yeah. Nor do they grapple with what we say is an ultra-virus placement. That's the main point of that part of the argument from my perspective. And if to see what happened in the context of the judgment itself. The judgment starts at B4. And there's a passage, the court will go to B32, 73 to 74, 73 to 75 rather.
Yes.
And the central reason is really the first 2/3 of 74, what would have seen. In the middle of 74, the judge says, in this context, the Supreme Court made clear in Ray T that having regard to the distinction between the power of the local authority,
It's the sentence immediately before that, is it?
It's both. It's as stated by the President when Ray T was before the Court of Appeal. An order under the inherent jurisdiction does not itself deprive a young person of his or her liberty. merely authorises the local authority or those acting on their behalf to do so should the local authority consider the action necessary. In this context, the Supreme Court made clear in Ray-T that having regard to the distinction between the power of the local authority conferred by the statutory regime and the power of the court under the inherent jurisdiction, the question of the legality of the placement under the statutory scheme is a matter for the local authority. The Supreme Court further made clear in Ray-T that in this context it's no part of the court's function to authorise the commission of any criminal offence, and that any order under the inherent jurisdiction does not do so. And then he goes on to say, second sentence in 75, decision by the court to authorise the deprivation of a child's liberty does not act to authorise the placement. The question of whether to place the child in a placement that is unlawful by reference to the amended statutory scheme remains one for the local authority and not the court. Now, pausing there, on the second part of the argument, is the judge's solution compatible with Ray-T properly understood? We say that that line of thought places the local authority in a quite impossible situation. They're being told that the legality of the placement is a matter for them, but they face on our construction a statutory bar to making the placement. It would seem to follow on ordinary public law principles that making the placement is ultra vires. Local authority's got no business spending money on it, for example. It's ultra vires the machinery. And although one can that's presumptuous, although one can make the distinction between criminalising the manager of the home and the placement itself, not easy to see how you simply put to one side a statutory bar to the local authority exercising a particular power, assuming that is what the regulations do, and say, well, it's up to the local authority to decide whether or not to exercise the power. Well, it isn't. I mean, they act ultra vires.
Is an answer that one's concerned with the legality of the detention when an order depriving a child of his or her liberty is being made, and the question of the lawfulness of the placement is part of what has to be weighed, but it doesn't affect the legality of the detention?
Well, my submission is that distinction, which is plainly present in the judge's mind and has been argued about, just the anathesis doesn't work. If you look at the structure of the 2020 regulations themselves, placement is a creature of the regulations that also contain 27 and 27A. There has to be a placement plan. Placement plan has to deal with the welfare of the children, of the child concerned, and so on. Now, all of that on our construction is unlawful. What's rendered unlawful is the placement.
Well, the matter is only before the court because to authorise the detention.
Yeah, yes.
If the placement didn't involve a deprivation of liberty, then the matter wouldn't be before the court.
No, it wouldn't. But it wouldn't be taking place either because it would be ultra vires. I mean, if one just thinks of the structure of the way in which the care regime works, I mean, I say this as an outsider to all of this, but I've slept some considerable time ago. But if you think about the structure of the way the care regime works, it's the placement is a central concept, as I understand it. You have to identify the placement in the care plan. You have to have a placement plan. That all has to be lawful, at least as within the formal vires of the local authority. If you don't have that, then the child doesn't get into the home. And that's the purpose, we say, of the prohibition in 27 and 27A. Because it's dealing especially with children under 16, and a conscious decision has been made by the drafting to prevent the placement of children in inter alia unregistered homes when they're under 16. So I fully understand the thought. I mean, the thought is powerfully put in the judgment, and I wasn't there, as your ladyship appreciates, when this was argued out for the first time. That there is a distinction between the deprivation of liberty and the making of the placement. Well, so there is, but that doesn't mean that even if you're looking at it in Article 5 terms, you can have a lawful deprivation of liberty in the context where the person who's doing the detaining doesn't have the virus to make the placement in the first place. So it just doesn't work like that, in my respectful submission.
But in terms of the lawfulness of what the court is doing, the court is not making the placement, and the court is not depriving the young person of their liberty. The court is authorising the local authority, if the circumstances require it, to deprive the young person of their liberty.
Yes, but it's authorising it in circumstances where the local authority will be acting unlawfully when it gets to that stage. And that's where we are. That's my submission. That is the difficulty which, with respect to the appellate judge, also faced up to.
So I'm so sorry to interrupt, but
No.
so your submission depends on the placement being ultra vires the local authority's powers.
Yeah.
The mere fact that it would be criminal to provide the children's home that's unregistered, or that's irrelevant. It's got to be ultra vires the local authority's powers.
Yes, I mean the local authority. Yeah,
Yes.
I mean it is actually it is ultra vires the local authority's power if we're right on construction.
If you're right.
We're right on construction. So I probably don't need to answer a hypothetical additional question of. But I mean, Lady Arden expressly contemplates a situation in which criminality is not incidental in the sense of it being created by the failure to register. So the manager of the home commits the criminal offence by not registering, but there's nothing unlawful about the use of the home. And that's a central distinction in her judgment. And by parity of reasoning, if the use of the home was criminalised, as she expressly says in terms, the result will be that the inherent jurisdiction wasn't available. Now we say you get to exactly the same place if instead of talking about criminality, you talk about lack of public law power. So we do say that paragraphs 73 through to 75 of the judgment that we're appealing against give rise to a very difficult problem for local authorities. You can't, no lawyer should be advising a local authority that it can act or advise, and it doesn't matter because the deprivation of liberty will be sanctioned by the High Court. Shouldn't be the way a sensible statutory scheme works. There may be a rejoinder to that which I won't foreshadow.
So we need, obviously, at some stage to go to the submission you make that this placement falls within the amended regulations.
Yes.
I don't know whether
that's my next stop.
That's your, well, then we'll go to that in an
Yes. Well, that's my way of introduction. If I could now invite the court to go back to the skeleton, our skeleton. Which starts, the grounds of appeal are A17, the skeleton starts at A19 in the core bundle. We set out in paragraph, under heading B, background, paragraph 7 to 22, the procedural history and the fact position. Now, I take it that the court doesn't need.
Yes, and we've We've followed that.
We can effectively take that as read. And obviously the summary of the facts, going back to the question about what happens at the end of this case, is potentially relevant, including in the update. But there obviously is a case where there are potentially grave issues about the engagement of Articles 2 and 3. So we will need to approach the final remedy in the light of that. But I don't think I need at this stage to say any more than that. Now, we then set out under the heading Children Act 1989, A24, paragraph 24. 22 concerns the general duty of local. We're now summarising the provisions in relation to the children contained in the Children Act 1989. Court will be far more familiar than me with these. But then we've come specifically to section 22C, which we say in the skeleton, section 22C applies to children looked after by our local authority, subsection 1. For subsection 2, the local authority must make arrangements with a child to live with a person falling within subsection 3. Parents, a person with whom a child was to live under a care order immediately before the care order was made, unless per subsection 4 would not be consistent with the child's welfare, etc. And then 22C provides if the local authority are unable to make arrangements under subsection 2, they must place C in the placement, which is, in their opinion, the most appropriate placement. That's a mandatory duty. You must go into the most appropriate placement. The court will appreciate that placement is a defined term in the regulations that contain 27 and 27A. I'll show the court that in due time. But subsection 6 says in subsection 5 placement means then A is placement with an individual who is a relative, B is a placement with a local authority foster parent who does not fall within paragraph A, C placement in a children's home in respect of which a person is registered under part 2 of the Care Standards Act 2000, or D, subject to section 22D, placement in accordance with other arrangements which will comply with any regulations made for this section. In determining the most appropriate placement for C, the local authority must, subject to subsection 9B and the other provisions of this part, particularly for their duties under section 22, give preference to a placement, and then your lordships can see what is done there and the factors that are relevant under 22C8 and 9. And section 25 concerns the use of accommodation for restricting liberty, Children's Secure Accommodation Regulations 1991. Then we come to the heart of the construction issue, which is it is set out by us in paragraphs 32 to 37 of the skeleton. And I think I can put the construction argument shortly by reference to the text as it's set out in the skeleton, although plainly the court has the full regulations in the authorities bundle. So you get, this is paragraph 32 of the skeleton, prior to the amendment which came into force on the 9th of September 2021, Regulation 27, providing for the general duties of the responsible authority when placing the child in other arrangements, provided as follows. Before placing C in an unregulated setting under section 26CD, the responsible authority must be satisfied.
Just pausing there, the use of the phrase unregulated setting, in Re T, Lady Black and others are plain to make the distinction between a children's home, which is either registered or not registered, but is always regulated, and an unregulated setting, which is what is said to be encompassed by some paragraph D.
Well, that is an important issue, because if you go back to 26D, as originally enacted, well, no,
it's still as it is, isn't
it's
it?
not as originally enacted, it is the primary legislation.
22(6).
22C6D.
Sorry. Anyway, footer by page 6. There's a list which we say plainly becomes a closed list by the time of the amendment, in which the local authority has a choice of 4 types of placement. And indeed, subject to 26(2)D,
22C.
sorry, 22D,
22D.
22 large D,
Which you have, we don't have
in this skeleton.
no.
It's not relevant, is it?
Yes.
It's review of child cases before making alternative. So it's just a procedural.
Yeah. It's in the authorities one.
Yeah,
Yes.
yeah.
Actually, I'm not sure it is.
It isn't.
Well,
I don't think it is.
do you want, are we going to refer to it? Because my lady won't have it. I've got it and my lord's got it. Do you want it?
It's
I don't think it's relevant.
the title of 22D, capital D, is review of child's case before making alternative arrangements for accommodation. Where a local authority are providing accommodation for a child other than by arrangements under section 22C6D, they mustn't make arrangements for C unless they have decided to do so in consequence of a review of C's case. So it's a procedural
To do with the
step.
requirement for a review.
I mean, we might have to come back to it.
Well, if it really does, it hasn't featured in my argument, but that doesn't mean anything.
Yeah, so it's subject to a
certainly doesn't
review
mean-
process, placement in accordance with arrangements.
But trying to deal with, I can get this provision right, 22C6D comes at the end of a list.
Which you say is a closed list.
We say it's a closed list. We say that becomes completely crystal clear when you read Reg 27
And 27A.
and 27A. It's a closed list which doesn't include an unregistered children's home for children under 16. That's
Every conceivable placement that's lawful has to be within 22C6D,
read together with
read together with 27
27 and
A
27A.
regulation,
Yes.
you say.
And we say that's deliberate because it's, 27A doesn't chime in terms of the age of the child with all possible placements. 27A doesn't bite in creating a closed list on children of 16 and over, if I've got the right way round. So we say, on absolutely straightforward principles of statutory construction, there's a discernible intention to ensure that children under 16 are in regulated settings.
But the wording of Regulation 27 is before C is placing C in an unregulated setting.
The original version.
The original version.
Yes, I'm coming on, so the skeleton goes on to set out, first of all, what it was originally, which is what we have at 32. Can I just finish the submission on 6, 22 large C 6D? Because it's a closed list, other arrangements, the natural meaning of other arrangements is other than those set out above. I mean, it's a relatively simple construction point. Other arrangements is not defined, not a defined term. So other arrangements, when it first occurs in the primary legislation, the natural meaning is other than those above. And that would mean as we see that when we get to the original version of Regulation 27, it was contemplating that the 22C6D arrangements would be unregulated arrangements, but there is an ambiguity about that.
Well, as originally drafted, is this what you say? 20, well, as it's still drafted, but under the original regulations.
Yes.
22C6D allowed for placement in unregulated arrangements because it only required that the arrangements comply with such regulations as may exist. If no regulations cover it, then it was an unregulated placement.
Yes.
And you say that's been closed off by...
It's been closed off by the amendment. That is precisely what we say.
Closed off for under 16-year-olds.
Yes, closed off
it's
in
still
relation
available
to
for
one set of
17.
the particularly vulnerable, yes. But I mean, in a way, that none of that matters. I mean, it's just a piece of construction. The other arrangements, I'm not sure that the arguments that range against me. The other arrangements in 22C6D simply mean other than those listed above.
But an unregistered children's home, so it would still be a regulated setting. It may not have got its registration, but it would still be regulated.
Yes.
And the difficulty with your submission is that what Regulation 27 said before amendment, it made clear that what it was concerned with is unregulated settings. Those are the other arrangements, aren't they?
No, with respect, that's a jump.
Is it?
It's certainly one of the subject matters of the original 27 was unregulated placements. On our side, we think there's some doubt about whether even the draftsman was facing up fully to the concept of unregulated on the one hand as opposed to unregistered on the other. But it doesn't matter because at the end of the day we have the submission that we make in paragraph 36 of the skeleton at E. I'll work through this list because it is our core submission at the end of the day.
But just before you do, I'm so sorry, can I just ask, if I've made a jump, can you tell me in C6D, 22C6D, where it talks about in accordance with other arrangements which comply with any regulations made for the purposes of this section, were there any other regulations made for the purposes of that section other than, before amendment, Regulation 27? Because if there weren't, then I haven't made the jump.
No, what your ladyship is assuming is that the unregistered care home...
No, leave aside unregistered. I'm on to a different point now.
Yeah.
I'm going at it another way. Were there, before the amendment that introduced Regulation 27A, any other regulations made for the purposes of 22C6D other than the original version of Regulation 27?
No.
Well, that makes clear then, doesn't it, that the accommodation being referred to in little d is accommodation in an unregulated setting.
No.
But otherwise, what is the purpose of those introductory words in Regulation 27? Before placing C in accommodation in an unregulated setting under section 22C6D.
I think the answer to my answer to this, right or wrong, will appear from just going through the whole of paragraph 36 and taking it in stages. Mr. Barnes was careful drafting, but I adopted. And your Lordship, my lady, will have picked up from the skeleton that we have the original version of 27 in paragraph 32.
Yes.
which does refer to an unregulated setting under 22(6)(c)(d), and then you need to be satisfied about suitability.
So before the amendment, before the regulations, the scheme posited both an unregulated and a regulated placement under D.
Yes.
Either was possible.
Yes.
Right?
We're really sure about it.
Well, under D it says the arrangements have to comply. Arrangements which comply with any regulations for the purpose of the section.
If there are any regulations.
Okay.
There are.
And 27, regulation 27 is drafted, refers to an unregulated setting.
Yes. Well, where you end up with that is little e on our paragraph 36. Either regulation 27, prior to amendment, took unregulated setting to include unregistered children's homes, or regulation 27 is simply silent about them.
Well,
They weren't covered by that provision at all, because unregistered children's homes are regulated even if they're not yet registered.
It's in your paragraph 36, it's little b that is the leap that you make, which I think is the point my lady has difficulty with, and so do I, where you say an unregistered children's home cannot fall within 22C6C.
Yes, because of the wording of 22C, because of the wording of the regulation, of the section.
well, also, I have a problem with your E, because your E says that under the old regulation, regulation 27 prior to amendment took unregulated to include unregistered children's homes, or was silent. The alternative is that it wasn't included in 27 at all. It wasn't included in 26.
Yes, that's I think what we're trying to say. It's court's putting to me, I think, that the words that fall out of D comply with any regulations mean that it needs to be positively authorised.
We're putting different things to you, to be fair to you. Forget what I put to you, concentrate what my lord put to you.
That may be true. I think I need, in connection with both sets of arguments.
Focus on my lady's point. That's what we'd all like you to focus on now.
Yes.
I think it's my lady's point. It doesn't matter because I've got to deal with it anyway. The court is obviously thinking that it's possible that C22C6D requires for something to fall within D to be positively authorised by other regulations. Whereas we say it's perfectly possible that, right, if there are other regulations which contain prohibitions or criteria which must be met, then so be it, that's easy. If the regulations are simply silent, for example, in relation to unregistered care homes, which we know from RAT were common and commonly used by local authorities at the time that these 27A and 27 were going through in their new form, perfectly possible for any regulation that's made for the purposes of section 22C6 to be simply silent on categories. It doesn't prohibit them. Any requirement for compliance is met by the absence of anything that they don't comply with. And my submission is that that's not actually difficult construction. I mean, it's where one would naturally get to, but for the very vexed subject matter of this field. So you have an unregistered care home before the amendment. Is it a placement that's available in relation under 22C6C? Answer no, because the wording of 22C6 says so, so we know it's not under C. What were the very many care homes that were being used? What power was being used for them? Well, the answer is there were arrangements other than those set out above.
Are you using care home and children home interchangeably in these submissions?
Yeah.
And if so, are you right to do that?
I think we need to stick to children's home.
Yeah, I think we need to fix with children's home.
I mean,
And can I just be absolutely clear? Are you saying that a children's home which hasn't yet been registered, or in respect of which a person is not registered, is an unregulated setting, or are you saying it is something else?
In the state of the drafting art that we now have, it plainly isn't unregulated. It is unregistered.
It isn't unregulated.
No, not as of today. If you ask the parliamentary draftsman to go away and produce a regulation that deals with unregulated and unregistered settings, then he would not describe an unregistered children's home as unregulated. I accept that. We know from Ray T that that was not always the case. But it doesn't matter to me because of the way in which we've addressed it correctly in 36 little e. I mean, either there is an ambiguity about the use of the word unregulated. It's the top of page A27, it's a split. Either there's an ambiguity about it, or we're simply not within the scope of Regulation 27 as originally enacted at all. And that's no doubt why local authorities weren't particularly fussed about routinely using unregistered homes for precisely this sort of thing. And the problem came with the new prohibition.
I think local authorities have been fussed a long time about all of this.
That may be too flippant. Yeah. But in any event, we know from Lady Black's judgment that they were unregistered homes were being routinely used. Or routinely may be too strong a word, but were used from time to time.
Demure, I think.
So, the only thing the only possible answer to our little e is that the fact that Regulation 27 is silent in respect of unregistered children's homes means that unregistered children's homes just don't fall within Section 22C at all. And that depends on the fallout words of D. Does the concept of compliance or accordance with other arrangements which comply mean that there have to be regulations which positively authorise the use of the unregistered home? To which we say, as a matter of language, the answer is no.
So is your case that now all homes are regulated?
Yes. If you ask me, the vast amount of knowledge I've gathered in a fairly short space of time, if you ask me now, is a children's home properly so that it is required to be registered? And we see a description of the registration regime in Lady Black's judgment. Are they properly to be described as unregistered or unregulated? The answer is unregistered if they haven't gone through the registration process.
I don't think we've got the children's home regulations, but I'm assuming that the regulations don't kick in only when you register. The regulations apply to anyone operating a children's home.
In terms of the correct view of the law, this isn't contentious. I mean, I completely accept and indeed positively put forward the proposition that if you are a children's home that's liable to registration, you are regulated.
You're regulated whether you're registered or not.
Exactly.
Yes.
Exactly.
And I'm looking
whether
at
that was always everyone's
Secretary
understanding is a slightly different matter.
Looking at the Secretary of State's skeleton, paragraph 16, there Mr. Orban says there's an important distinction between an unregistered setting, one which falls within what is a children's home but hasn't been registered. This is the territory of section 22C6C and constitutes a breach of the requirement in that provision for registration. So you take it, your submission is distinct to that because you say, look, some section C says it only applies when there has been a registration. Yeah. It's not sufficient to say it's in the territory.
Yeah, exactly. I mean, there are a number of departures between our approach to construction of these provisions and the Secretary of State's. We say, this is an orthodox statutory interpretation, the intention of the draftsman, we've called it Parliament in our skeleton, but actually it's Secretary of State, it's the Board of Legislation. The intention of the draftsman is to be discerned primarily from the language that's actually used. So when you get a closed list, as in 22C6, and a reference to other, the natural meaning is other than those set out above. Now, Mr. Oberlin says, well, hang on, that's not right. I'm not quite clear why linguistically he said it's not right. There's partly a sense that registration can be dealt with by making an application to register, perhaps.
We're coming on to the new regulation, are we?
Yes.
And 27A.
Yes.
Does that contain a comprehensive list of other arrangements?
Yes. For under 16s. If you're
well, you're coming on to, in your own.
Yes, I mean, I slightly jumped to the summary, which is in our in 36, but in 33 and 34, the skeleton. We set out the text of the new regulation.
So I'm playing catch up. So going back to the point that I was on a short time ago, you accepting that whether or not it's registered or not, if it's a children's home, it's regulated.
Yes.
So before the amendment, looking at your paragraph 32 in your skeleton, regulation 27 did not apply to those.
I haven't quite accepted that because that's
before placing C in an unregulated setting.
That's a question of when the language started to be accurately used. So of course, I don't think it matters in the sense of the ultimate result.
But your submission may be that the new regulation jettisons that phrase, unregulated setting.
Yes.
And so if an unregistered children's home couldn't be part of regulation 27 before, it now can. Because it's another arrangement. It doesn't fall within.
It's another arrangement.
It doesn't fall within little c, so it's another
children
arrangement.
Over 16, that is precisely what we say the situation is. Now, it may have been always, but certainly is now.
Yes.
That you're not within 22C, little c, because you're not registered. The home is not registered. You are potentially within C, little d,
Yes.
except that the prohibition, that's the point at which the 27A prohibition kicks in.
Yes.
No,
I see what you're saying.
I mean, the challenge for various people who are arguing the other side is to explain what they think the position is in relation to children 16 and over who don't fall into the prohibition.
I'm beginning to see why Mr. Justice MacDonald did not answer this question.
Yeah. It's a slightly ambiguous way of not answering it, because he did accept, in contrast to the Secretary of State's present submissions, that there was a prohibition contained in the new 27 and 27A read together.
Yeah.
But I mean, just to complete the submission, so that, just to repeat it actually, I'm sorry about that, but if you have a child, a 17-year-old child, for example, in an unregistered home, home that is capable of being registered and is therefore regulated but is not registered, it will not be dealt with, that home will not be dealt with under little c, but is potentially capable of being dealt with under little d as an other arrangement, because it's not prohibited by 27 large A.
But are there other regulations that will regulate that placement?
No. Ofsted have certain powers, simply because it's within the regime of regulations your Lordship has accurately put to me. So it's potentially in a regulatory regime, it's just not registered. And Ofsted can inspect and has enforcement powers and so on. As Clement will tell us about in relation to such a home.
But under the previous regulation, unregistered children's homes did not fall within D.
Well, your Lordship says that. I don't accept that.
Well, that's what, isn't that what the consequence of what Lady Black said? Because Lady Black said, when an establishment is a children's home, it is undoubtedly regulated, even if it is not registered. That's what she says at 58. So if all children's homes are regulated, why does it fall within D?
It falls within D because it's not taken out by anything. It's that goes back to the debate that we keep on coming back to about what the concept of complying with any regulations made under the section means. On that example, the simple silence about the unregistered but regulated children's home. So it doesn't fall on that basis within at least the present meaning we will give to an unregulated setting, because it's capable of being registered and it is in a regulatory regime. Equally, it's not prohibited by any regulations made under 22C6D, if that's the correct meaning to be given to those fallout words. And I say it's the natural meaning to be given to the fallout words. So, if I can answer Lord Justice Baker's question and go...
Well, we're coming, I'm looking forward to coming on to 27A.
27 large A, yeah.
Only when everybody else is happy we get to it.
Well,
I think we're there, aren't we?
I think we're pretty well there.
Okay. So where do children's homes appear in 27A?
They don't.
27A refers to care, not children.
No, they're not in, that's the whole point. So, 27A is in prohibitive terms. It prohibits placement in accordance with other arrangements under 22(6)D, unless, it's may only is the word that's used, it falls into one of the other settings which are listed in 27 large A.
What's a care home?
Okay. It must be related to...
Where is care home defined?
I'm not sure that I know the answer. See if the regulations are. I don't immediately know the answer to that, I confess. We say the regulation works
Yeah.
Have we got the whole regulation in hand?
We've been very helpfully told. I was covered as junior that regulated activities are listed in Schedule 1 of the Health and Social Care Act 2008 Regulated Activities. Regulations 2014.
The Health and Social Care
Last point to Mr. Spencer.
Schedule 1
Act.
of the Health and Social Care Act 2008, brackets, regulated activities, close brackets, regulations 2014. So that's talking about a set of 2014 regulations.
Under the 2014.
Under the 2008, under Schedule 1 of the 2008 Health and Social Care Act. And they include personal care and accommodation who require nursing or personal care. So that would, I suspect, include accommodation used for personal or nursing care of children under 16. That would not be the paradigm case, obviously. Care home would normally be
My Lord, if it assists, Section 3 of the Care Standards Act, which is not in the bundle for some reason, defines the term care home in England. And it's an establishment is a care home if it provides accommodation together with nursing or personal care for any of the listed persons.
So it's persons who require nursing care. Is that
Yes.
So it's a narrow.
Nursing or personal care.
And subsection 4 says not a children.
Yes, so, my Lord, we can provide Section 3 if
Okay.
it helps. So it's for defined categories, persons who are or have been ill, persons who have or have had a mental disorder, persons who are disabled or infirm, and persons who are or have been dependent on alcohol or drugs. And then it excludes an establishment is not a care home if it is a hospital or a children's home.
So a care home is not a children's home.
Yes. If it is a children's home, it can't be a care home.
I know, and that works because a children's home, whether registered or not, is always regulated by its own scheme. And we're only talking about this because of the word in some subsection C is registered, or a person is registered. Right,
Yes.
that's the only reason. That's the only reason you say an unregistered children's home falls outside some subsection C.
Yes. It's simply not, yes, exactly. I mean,
So, yeah.
not in C. That may not matter unless you're a child under 16 caught by the prohibition.
Yeah.
Because on the shape of the new regulations,
Yeah.
the prohibition doesn't bite
Yeah.
on regulated but unregistered children's homes.
Right.
So, and just to be clear, I'm sorry, I'm being slow. All the closed list at little a of new 27A are all regulated settings.
Yeah. Yes,
So
they're
there's no
regulated
longer
under
an-
different regimes, but they are all.
But so if one were looking at the mischief that was intended, it was to avoid placements in an arrangement, even if the local authority thought it suitable and it wasn't reasonably practicable. Thought it suitable and had arranged for C to visit the accommodation. It could be an unregulated setting under the old regulation. Now it can only be a regulated setting. And so what's happening on your construction is the regulated children's home is the only one that is excluded, even if, because it merely by virtue of the fact that it's unregistered, which is an odd result, isn't it?
Well, the agency says it's an odd result. So what the draftsman of 27 large A has obviously done is provide a closed list of accommodations that was to be regarded as acceptable to accommodate children under 16. And hasn't included in them, in that list, children's homes, which the only route is little c, which requires registration.
But it is odd that under 16s can be put into a whole range of other regulated settings, but can't be put into a children's home, which is regulated, where the registration process has not been finalised.
I would need
And indeed, they can even be put into a school that is not registered as a children's home. But they can't be put into a children's home that is not registered as a children's home. We see that from Little 4, don't we? So they can be put into a school that provides accommodation that is not registered as a children's home, but they can't be put into a regulated children's home that is not registered.
Yes, but if your ladyship thinks about the Roman 4 wording, you're only out of the school if you're registered as a children's home. You're not out if you're registrable, if that makes sense. You're not out because you're potentially regulated under a children's home. The draftsman is doing exactly what he's done by leaving untouched the primary legislative position, which is in 22C D. The school within the meaning of Section 4 of the Education Act 1996, provided that the accommodation is not regulated. It's not registered.
Registered.
I know, that's not what it said. It says registered. So it's requiring actual registration, which is exactly my case in relation to 22C, little c.
Sorry, I haven't followed that. It isn't registered. It's a school that's providing accommodation that isn't registered as a children's home.
It doesn't say which is not capable of regulation as a children's home. It says which is not registered.
But I think my lady's point is, putting it in a nutshell, it's really odd if we're dealing with under 16-year-olds that it's now unlawful to place them in an unregistered children's home. You could put them in a school that's not registered as a children's home. You can put them in a care home or hospital.
Well, your Lordship says that. I mean, your Lordship's own guidance talks about the need to bring unregistered placements back into the fold as rapidly as possible. What I say has happened here is that the natural meaning of 22 large c, little c, 6 little c, is that home needs to be registered for a placement to be available. And there's a perfectly sensible policy reason for that, which is that all the checks on the suitability of the personnel and the safety of the accommodation and so on have all been gone through, so that the local authority knows that the placement is satisfactory precisely because the home is registered. Not that
So you say it's not odd because
exactly.
the mischief, to pick up my lady's phrase, is to stop the use of unregistered children's homes for under 16-year-olds.
Yes, and your Lordship will probably recall that in Lady Black's judgment in Ray T, which is picked up, I think, in your guidance, and certainly is picked up in the latest judgment on the need for relatively strict compliance with the guidance, Lady Black talking about how it potentially matters that although you're capable of being registered, you're not registered. Many a slip between cup and lip, effectively. You may fail, in which case you're even worse off. You're capable of being registered, but you fail to meet the standards.
Mr. Auburn, and indeed the judge, referred to the explanatory memorandum to the new regulations. Do we have that memorandum? in the,
Certainly, it's physically in the court.
is it in the list, the bundle of authorities?
So we've got the,
We've got,
The wrong one got in. I think the actual answer to your Lordship's question is the wrong one got in.
well,
I thought
that is the answer, then it explains why I'm looking
Why you haven't found
for the
it.
wrong thing.
Yeah.
it'd be good to have it.
It'd be good to have it, because the judge referred to it, Mr. Auburn refers to it, and I think Mr. Cameron refers to it too.
Yes,
And if obviously you're going to say it's not part of the regulation.
well,
But Mr. Auburn is going to say that tells us what the intention behind the amendment was. I really would like, for my part, would like to see.
we plainly need it, and
If we can get
Just
it during
to
the
be
short
clear,
adjournment.
I don't dissuade from that, but we do have the explanatory notes to the Children and Young Persons Act 2008 in the bundle, which is at D1, just to be clear.
Yeah, but that's not the one that
it's not.
Mr.
There is a fuller and longer one, which I saw last night, and I haven't managed
Yes,
to be
it's
organised
the
enough to
expansion
bring with me.
memorandum to the new regulations.
New regulations. I completely
The judge refers to a paragraph 39, and I thought that's what Mr. Auburn was also and Ms. Cameron also.
My Lord, Mr. Spencer, once I give him the email address, will email it to the President's clerk and your clerk, if
Yes,
may, and then
we'll get here quicker than
copy.
to my clerk, who's on this side of the building, as opposed to the President.
in which case,
Assuming she's on this side.
okay, apologies.
Thank you.
Yes, I mean, the learned judge, if we look at paragraph 39, this is a submission that Mr. Auburn repeated in the hearing about the President's guidance.
Yes.
Made it clear the government took the view that the term other arrangements in 22C6D was intended to refer mainly to independent and semi-independent settings for older children.
But not puzzles me, what I notice about that sentence is that that is the memorandum to the regulations explaining the purpose of the legislation. The previous legislation, not the regulations, doesn't it?
Yeah, well, I have to say I find it very opaque because it talks about referring mainly to, which is question begging. I mean,
Yes.
the question
Doesn't
is,
exclude what you're arguing.
no, not at
No,
all.
no.
I mean, and as I've already submitted, and it's a trite submission, you discern intention from the natural meaning of the words primarily.
And
You
the
can
list,
state
the list in 27A,
that. Yes.
is that independent and semi-independent settings?
It's not semi.
It doesn't.
No.
It's
No.
it's a different. I don't want to use the word. Forgive me for using the word institutional, but I can't think of a better word at the moment. It's different sorts of institutional settings, hospitals,
Yes.
care homes, as you've
It's
now
not.
explained.
It's not the classic unregulated, to use the current meaning of the word unregulated, as I understand it. It's something outside a regulatory regime, the holiday home or the longboat or whatever it is, the unregulated. The list is not that at all. The list is of, well, your Lordship has
Yes.
can
And
see
that's
the
because the aim is for those under 16 only to be in a more structured setting
Yes.
than the semi-independent living that older young people could
Yes.
be
But
provided with.
Does this mean that the effect of regulation is to narrow very significantly the scope of 22C6D?
Yes. In relation to children under 16. It's the may only, it's the prohibition that is where 27 large A bites.
I said we might have to come back to 22D, because 22D is about reviews,
Yes.
and that would apply perhaps to independent and semi-independent settings. I don't want to take you off track. Anyway, okay, thank you. It will be useful to have that memorandum.
We'll get the memorandum. I did actually.
The wrong one's here.
Your
It's
Lordship
Cavaliers.
wants to know whether I looked at it or not. I did look at it, but I haven't been organised enough to bring it with me.
So there was a happy moment at the beginning of the hearing where you indicated you may not take until lunchtime, but we've
You have asked some questions.
we have asked a lot of questions.
I thought we'd stayed silent.
No, we haven't stayed silent. So this is not to be critical, but I think we can now see the the problem, and I can certainly see the line of argument that you and Mr. Barnes are submitting.
Yes. Well, I think I've got two things. I can actually just run through our list of the, in I think whatever paragraph it is of the skeleton, 36.
Mr. Barnes.
It is indeed Mr. Barnes. I don't disguise that at all. But it worked.
Yeah.
I mean, so I thought it worked.
36.
And then go to in Ray T. I've got a sort of
Yes.
short series of propositions about what Ray T establishes or doesn't establish. And then the question of reading the judgments through negatives by and large.
For my part, I'd like you just to nail down your submission that what Lord Stevens and Lady Black say doesn't, as it were, contradict what Lady Arthur says.
Yes, I'll try and
You've made that assertion there.
I've made that assertion. I'll try and get it right. Yep. Okay. So we have seen, I think, now the text of 27 and 27A. So the new 27 is only dealing with other arrangements under 22.6D. So that's a narrowing of what it was before. Sorry, well, it's a difference from what it was before, because the previous one referred to unregulated settings. And then 27A may only place a child under 16 in accommodation in accordance with other arrangements under section 22C6D, where the accommodation is. And then
Where are you reading now?
our paragraph 34 of the skeleton,
Right.
which sets out the text of the regulation. And then we say in 36, and if I can just work through these, 1. A, the definition of placement in 22C5 as set out within subsection 22C6 is a closed list into which a local authority must place a child if the arrangements cannot be made under 22C2. I think that's self-explanatory. B, an unregistered children's home cannot fall within 22C6C. We've debated that. Of course, we say the wording. All other classes of accommodation which do not fall within subsections 22C6 until A to C fall within the ambit of 22C6D. That's the significance, I say, of the word other. It's a closed list, and other means other than those set out above, subject to the prohibition in 27 large A. D, prior to the amendment to Regulation 27, placement in an unregulated setting was permissible, subject to satisfying the conditions set out therein. That is question begging to an extent about the fallout words of little d. And then C, either Regulation 27 prior to amendment took unregulated settings to include unregistered children's homes, or Regulation 27 was silent in respect of unregistered children's homes. Thus, placement within an unregistered children's home was either permissible on satisfying the conditions under Regulation 27 or fell outside the scope of the regulation. G, the amended Regulation 27, by moving the wording of 22.6D, other arrangements, makes it plain that it applies to all classes of placement falling within the subsection. And the list of 27A, little a, makes it plain that other arrangements include placements that go beyond unregulated settings, and we say in the brackets, indeed most, if not all, placements are in settings which are subject to regulatory schemes, and is itself a closed list.
Do you say it's all, or rather than most? I was trying to look at where the Care Standards Act talks about care homes and their regulations, but it doesn't seem to. It just gives the definition that we were.
I think, in fact, the whole, all little 1 to little 5 will be establishments that are subject to some degree of regulatory control.
Right, so they're all
I
regulated
don't
settings.
pretend to know the detail of the control.
The logic of your argument is the Parliament closed off any unregulated settings for children, these
Children under 16.
children with particular problems,
Yes.
or any children, Any children.
Yeah, under 16. Yes.
Okay.
Yes. Oh, yeah.
That's the
That's
scheme.
correct. Now, whether that's sensible legislation is not at the end of the day for me. I mean, but that is, one can understand, to say that there's a policy reason for construing a 27 large A contrary to my submissions depends on finding some identifiable rationale for a closed list.
Well, it's probably quite important to your principal argument, isn't it? The Parliament has decided, Parliament, approving these regulations, assuming, they've been approved by Parliament, has decided that all placements must be in a regulated setting. And that's important to your Article 5 argument.
Yes, absolutely. It's the may only. I mean, you're closing off the possibility for those under 16.
And it's probably important for your second ground of appeal as well.
Yes, it is. I mean,
It establishes it. I'm not saying I agree with it, I'm just focusing on it. It establishes a clear statutory scheme, no placements outside regulation. And for the inherent jurisdiction, you say, to use the inherent jurisdiction in the way which is being used up to now would cut across the statutory scheme.
in relation to the 27 large... Sorry, my lord,
if it's as clear as you say it.
Yes. I'm interrupting, but
No.
yes, it is my case that the intention was to make it unlawful for a local authority to place a child under 16 in any setting other than those within the closed list to be found in 22 large C and read together with the list in 27A. That's it.
Subject to operational necessity.
Subject, importantly, to operational necessity. And I mean, you do need to bear in mind, just as a background to the possible policy drift, is that all of this was going through in the form of the regulations at the time that AT was either being argued or or in the process of the gestation of AT. Strasbourg certainly knew an argument was going on about the scope of the desirability of unregulated placements for young children. So we say I think I've read little h, and then I is a submission that having widened the scope of Regulation 27, the effect of 27 large A is the local authority may only place a child who is under 16 in accordance with the other arrangements, where the setting falls within the list of 27 large A little a. The local authority has just provided placing a child under 16 in an unregistered children's home, noting that the equivalent prohibition applies, that no equivalent prohibition applies to the placement of an under 17 or 18-year-old. And then we make the submission 37, which I think is what your lordship was putting to me. So those are the submissions on construction. I'm afraid that did take longer than
very
I
helpful.
meant to take. But I mean, the other issue is how all this relates to AT.
Yes.
And therefore, through Article 5, together with the cutting across the statutory scheme, and they're both I make it plain, both of those are important. If I'm right and there is an express considered prohibition, then for the reasons given by Lady Arden, but we'll see how they relate to Lady Black and Lord Stevens in a moment. For those reasons, the inherent jurisdiction would not be available. So I've got 7 propositions. I can just I can try and reduce them to typing at some point during the hearing, but I could just read them now. The 7 propositions supporting the submission that this situation is not covered by RAT. So firstly, we say the regulatory regime is a crucial safeguard forming part of the domestic scheme authorising detention of children under 16. So the regulatory regime is a crucial safeguard. 2, since the enactment of Regulation 27 and 27 large A in its present form, it has been ultra vires for a local authority to place a child under 16 in an unregistered home. Third proposition, thus the present form of Regulations 27 and 27A are part of the safeguards built into the domestic scheme authorising detention of children under 16. The fact that the local authority acts ultra vires if it makes such a placement is itself a safeguard.
Sorry, you move fast.
Present form of Regulations 27 and 27A are part of the safeguards built into the domestic scheme authorising the detention of children under 16. The fact that the local authority acts ultra vires if it makes such a placement is itself such a safeguard in relation to children under 16. Fourth, and this is an assertion, I'll try and make it good, the ability of the High Court to authorise detention by the local authority cannot and does not cure the illegality inherent in an unlawful placement. The detention necessarily takes place in the context of the placement. The detention and the placement are inseparable.
Can you...
Sorry, too fast, sorry.
Yeah. The ability of the High Court to authorise the placement cannot...
You authorise detention.
Authorise detention
authorised
by a
dolls
local
cannot...
authority is what my phrase goes.
Cannot
And does
cure
not
the
cure the illegality inherent in an unlawful placement. The detention necessarily takes place in the context of the placement. The two are inseparable. Fifth proposition, neither Lady Black nor Lord Stevens regarded the placement they were dealing with in Raytee as beyond the power of the local authority. They considered that the possible commission of an offence by the operator of the home did not fundamentally affect the legality of the actions of the local authority. We submit this is a crucial part of their reasoning, which is not available now. So that's Lord Stevens and Lady Black. Lady Arden, sixth proposition, regarded it as crucial that the criminal offence concerned only the lack of registration, not the operation of the home. The operation of the home was not criminalised. And 7, we say it follows that where one of the main actors in a case concerning the making of a placement that is expressly prohibited, detention that takes place in the context of that placement is not lawful.
Just say that again, when one of the actors...
I've got down actors, I mean local, well, one of the two parties, local authority or court. In a case concerning the making of a placement.
In a case concerning the making of a placement.
That is expressly prohibited. detention that takes place in the context of the unlawful placement is not lawful. Now, I've got to make good, I think, the proposition that although Lady Black and Lord Stevens don't agree with Lady Arden, they do not treat the placement as ultra-vires. The placement in Métis as ultra-vires. It involves the commission of an offence, but by the operator of the home, not by the local authority, not by the court. That's a crucial point that is true in all three judgments. So if I can ask your lordship and my lady to pick up, first of all, Métis.
That starts at B35 of the...
Yes, I've had authority bundle problems, so I'm working off the internal paragraph numbers. I hope that works. Court will be much more familiar than I am with this background. Paragraph 30, if I can pick it up there, it's in page 654 of the report.
Yes.
And the Lady Black goes through the scheme of the Children Act 1989 dealing with section 22, and at just below letter C on page 655, section 22C5 and then section 22C6 deals with what is meant by placement. Your lordship and the lady will see that in 33 she says that 22C6D merits a little more consideration, and comes directly on to the subject matter of this appeal just below letter F. Since the hearing of this matter, further provisions have been added to the regulations by the Care Planning Placement and Case Review England Amendment Regulations. These amending regulations alter the wording of Regulation 27. They also add a new Regulation 27A. The lecture says these changes will be taken into account when they are effective later this year. And then there's a reference to 22D, which we need to pick up. And then 34, also to be found in the Care Planning Placement and Case Review England Regulations, is a more generally applicable structure for matters such as care planning, including the preparation of a care plan, placement, visits by a social worker for children's in placement at specified intervals, and regular care reviews for looked after children. And if your lordship and my lady will go to C5 in the authorities bundle, you will find hopefully the relevant text. 2010 regulations. As a general point is the concept of a placement, which is what 27 large A bites on, is a pretty important concept for the operation of the care planning regulations. And so that you will find definition of placement at C7, one third of the way down the page. Then there's a concept of a placement plan, meaning given in Regulation 9(1)A, immediately underneath on C7. And then at C8, heading care planning, so regulation 4 requires assessment of the child's needs, and then 4 subregulation 3 says when assessing C's needs under paragraph 1, the responsible authority must consider whether C's placement meets the requirements of Part 3 of the 1989 Act. And then 5, the care plan must record a record of the following information. And then little c requires that to include the placement plan, which is itself dealt with under Regulation 9, C11.
Just to help me, what's the point that you're seeking to make on the back of this?
The point on the back of this is the placement is a central concept. It's the placement that's prohibited by 27 large A, and it therefore follows that it's not only the physical putting of the child into the accommodation,
That's the whole process.
but all the trappings.
Yeah.
That's, I mean, yeah. And so if you're looking at safeguards that are in play from an Article 5 perspective, all of this is unlawful. If I'm right on construction, you can't have a placement plan that identifies an unregistered children's home for a child under 16. You can't make the placement plan. And all the trappings. I don't think I need go beyond 9A.
No.
They don't go on. That's the point.
And none of this has been changed materially by the regulations.
No.
These we've seen these, well, for my part, I've seen these regulations in other contexts.
Yeah, I'm sure the court is
Well established.
very, very familiar with them. And they're not changed. I mean, all that happens is that the 27 large A takes out one sort of placement, which therefore can't be the subject matter of all the machinery that's otherwise available in these regulations. Now, in a sense, it would be possible to fall through AT paragraph by paragraph through the judgment, but I'm not sure that's going to be all that useful. There are some crucial passages which are not compatible with the view that Lady Black thought that the placement was unlawful. And if the court will look first of all at paragraph 114. Court will recall that I think it was child in Beatty, had an argument that the inherent jurisdiction wasn't available because of the terms of section 102 little d of the Children Act, I think. Secretary of State's answer to that, which is entirely compatible with my case today, is at page 114, internal page 673 of the report. 673 of the report. Lady Black records the fact that in his written case, the Secretary of State puts the case against the appellant's section 102 little d argument very simply. It seems to be essentially correctly. The remainder of this paragraph sets out the essence of his argument. He submits that the orders made here under the inherent jurisdiction did not confer on the local authority the power to determine any question, let alone any question arising in connection with parental responsibility for a child. The local authority already had parental responsibility by virtue of the care order, and T being in their care, they had a duty to accommodate her by virtue of section 22 large A of the 1989 Act. what the court's order did was authorise the local authority to deprive T of her liberty in certain placements in accordance with their care plans. The court determined that this was lawful in accordance with Article 5. Once it authorised the placement, the local authority merely exercised the parental responsibility that they already had by accommodating the child and caring for her in accordance with the care plan. The Secretary of State seeks to confirm this interpretation by looking at the mischief that Section 100, subsection 2 was intended to address. This demonstrates that his submission is not intended that Section 102D will bar the exercise of the inherent jurisdiction in this court. Now, I mean, that formulation is entirely compatible with my case. It's not a hint of it, hint of a submission or any finding by Lady Black that the placement was unlawful. It's just not what authorises the detention. At that point, there is a distinction between detention and placement. But the formulation, which is the Secretary of State's formulation at this stage, what the court order did was to authorise the local authority to deprive T of her liberty in certain placements in accordance with their care plans. It's in the placements, which axiomatically the local authority...
Does Lady Black agreed with that and then developed the points in the ensuing paragraphs? Does she come back to this particular point that you're
I think
highlighting?
If we go on, if I can ask the court to then at
But
129...
I'm so sorry, before you do, are you saying that Lady Black was assuming that the placement itself was lawful rather than the authority, rather than the fact that the court's order authorised the local authority to deprive the child of its liberty in whatever placement the local authority chose, whether lawful or unlawful?
He's assuming a pre-existing placement with a care plan which has consequences for the deprivation of liberty, which is authorised by the court order. Certainly doesn't come anywhere near to say that she was contemplating authorising a deprivation of liberty in the context of an ultra-virus placement.
Well, for my part, I would like to see how she develops it.
Yes,
because obviously that's the summary that she's there.
Well, indeed. Yes,
whoever it was, his case wasn't just the local authority's case. Miss Weston's case. How does she develop it?
Go on.
Focusing on this crucial point: placement or detention.
Yeah. 129.
One, 2, 9.
129 is my next port of call. This court is in no position to make its own factual finding at this stage as to whether placement 1 was a children's home or not. However, CCBC accepted it was, and it is in any event impossible to ignore the use of placements which are in fact children's homes and are unregistered. It's clear from other cases in the law reports that the inheritance jurisdiction is being used to authorise the placement of children in accommodation which should be registered as a children's home, but is not so registered. This is underlined by the fact that the primary focus of the Principal Practice Guidance issued by Sir Andrew McFarlane is said to ensure that when a court authorises placement in an unregistered unit, steps are immediately taken by those operating the unit to apply for registration if the unit requires registration. So I suppose it can be said against me that that's compatible with the court authorising the placement. But that's not the way in which this debate is traditionally put. It's traditionally put on the basis that the placement is an issue for the local authority, and it's the court that's concerned with the deprivation of liberty in the context of that placement. And if your lordship and my lady then go on to, I am rather selecting other passages that come near to being this. 141. classic statement about the absolute necessity of having the inherent jurisdiction to deal with some of these very awkward cases. And she says in the last third of 141, just below letter F, cases such as those to which I have alluded earlier in this judgment demonstrate, it seems to me, unthinkable that the High Court, with its long-established role in protecting children, would have no means to keep these unfortunate children and others who may be at risk from them safe from extreme harm, in some cases death. And then says, if the local authority cannot apply for an order under section 25, I would accept the inherent jurisdiction can and will have to be used to fill that gap without clashing impermissibly with the statutory scheme. Now, my comment on that is that that is not addressed at a situation where the placement is prohibited by legislation. So, dealing with a situation where authority for the deprivation of liberty is needed because of the non-availability of secure homes. There's no question of the underlying placement being unlawful or prohibited by a statutory provision. And then she goes on to explain at 143 to 147, the whole passage is a fairly central passage.
What distinguishes this case then, from what Lady Black is talking about in these paragraphs?
What distinguishes it in this case is that there is a straightforward prohibition on the making of the placement, which is the...
What you said, it's paragraph 145, which we're coming to, where Lady Black says, I've been particularly concerned as to whether it's permissible to exercise the inherent jurisdiction to authorise a local authority to place a child in an unregistered children's home in relation to a criminal offence would be being committed, brackets, by the homeowner.
Yes, and the brackets being... Sorry.
And that's my brackets, but you latch on to those, because you say the difference now is it's not the children's homeowner who's committing a criminal offence, it is now unlawful for the local authority to make the placement.
Yes.
That's the difference.
Yes. Yeah. It's shifted from the criminal law to my territory public law.
You say that, as Lady Black in 145 goes on to say, well, that's regrettable that a criminal offence might be committed, but the local authority and the court have to act in these really hard circumstances, and it's justifiable where there's no alternative, and the way around it is to use the President's guidance to ensure that the criminal offence, non-registration, is neutralised as soon as possible.
Yes, exactly.
But you say that's no longer applicable because the context now is that it's just unlawful for the local authority to make the placement.
Yes, and so and for all the reasons I've been giving, that goes to the very heart of the exercise of dealing with these children under 16.
Yeah. And so your submission is that insofar as the other parties to this appeal say, and indeed Mr. Justice MacDonald said, I've got a safety blanket of RE-T here, I'm doing no more than happened in RE-T, you say, no, it's changed because of the new regulation.
Yes, because there is a prohibition. And so if you ask our second ground of appeal question, is there a bigger conflict with the underlying statutory scheme in our present circumstances than was in RE-T? You get a very firm answer, yes, there's a very, very bigger conflict.
And whether your submission is made good in the end, that's how I certainly understand it.
Your Lordship is entirely right, that is the submission.
And it doesn't matter that the express prohibition on your case comes in secondary legislation rather than primary legislation.
That might go to the violation of secondary legislation, and or to the issue of whether it can be disapplied in deference to a convention right such as Article 2 or 3 held by the child in question. Maybe even the primary legislation will give way in an Article 2 or 3 case, but certainly secondary legislation could simply be disapplied if the consequence is death or serious injury.
Of course, Lady Black wasn't saying, giving the green light to these, the authorisations in these circumstances where the criminal offence was being committed. She goes on, this is where she talks about the imperative considerations of necessity.
Yes.
And likewise, you accept that a similar exception applies now to the court being able to authorise placements in such circumstances. Operational necessity, as you conceded.
Yes, well, yes, I mean, that goes back to our exchange at the very beginning. I don't think I can say any more than I have already said about that. But the analysis has to proceed, not on the basis that there is some general inherent jurisdiction which can override such prohibitions of this sort, but on the basis that they are indeed effective, but that the UK may be caught by a need to comply with the operational requirements of Articles 2 or 3. So that's the nature of the subject matter.
So the last two sentences of 145 apply in the present case as they did in Reed T.
Well, I think if we go on, it may be a graded situation. You have the criminal offence, graded situation.
Yes.
You have the criminal offence, which is not aimed at the local authority or the court. And I think, I'm speaking from memory, but I think I'd like to come to a passage where Lady Black says precisely that, or maybe Lord Stephens. So, an offence committed by the owner of the establishment in not applying for it to be registered, but the activity itself of making the placement is perfectly lawful. That is the subject matter that Lady Black's actually dealing with, and that's
the context. We must. The context of all this is the complete shortage, total shortage of accommodation. You said as part of your first proposition from Reed T was that the regime is a crucial safeguard as part of the domestic scheme. If the regime is in the context of there not being anywhere like enough places that meet, then it's no safeguard at all, is it?
I would positively assert that. I mean, I can't, there is a submission, which I don't think I can make in this case, that the UK is in breach of Article 5, not because of the absence of a lawful read, not because it's not in accordance with law, but because you've got a convention duty to resource the safeguards which your domestic law requires you put in place. You can't just have the safeguards and then pretend they don't exist, or they're not necessary, by failing to fund them. And we know that the local authority and the Secretary of State fall out about whose fault it is, but the authority, there's an authority cited by the judge at the very end of his judgment in the President's Guidance cases, the case called, it doesn't matter what it's called, the Strasbourg Case, which held Ireland, the Republic, to be in breach of the Convention for failing to fund sufficient accommodation for children as opposed to adults.
Yes.
The child ended up in an adult establishment. Everyone, including the doctors and the actors, as it were, acted as reasonably as they possibly could under the Irish regime, but a breach by the Republic of Article 5 for failing to provide the safeguard.
Well, until such time as somebody does bring such a claim,
then it's just
family is having to deal with these problems.
Yes, exactly.
A dozen or more cases every week.
I
More.
understand. Well, I understand that. Yeah. But in any event, the formal submission is that Lady Black, at the end of 145, is not dealing expressly with this situation where there's a statutory prohibition in place.
Well, why shouldn't the same? Why shouldn't the court conclude that the imperative consideration of necessity lead us to conclude that the inherent jurisdiction must be available in the cases, even if you're right about the statutory construction?
I think what the President put to me is the effect of our submissions will be to narrow.
I said to tighten the squeeze on local authority.
It squeezes the local authority, yes, exactly. We'll shy away from that, it squeezes the local authority. They will get out of the truly unthinkable cases where a solution needs to be addressed. They don't get out of pejoratively when they will have an operational duty to ask for the help of the court in avoiding an Article 2 or 3 breach. But you've jolly well got to get to that stage. You can't just resort to, again, inherent jurisdiction routinely.
Yes.
The carte blanche reference is at 155. And at 163, Lady Black repeats the sentiment that your Lordship has just put into me.
At 166, did you say?
163, I said.
163.
Well,
I heard 160.
I probably said 166, but in which case it was a mistake.
Yeah. So do we need to go to
Stevens?
Lord
We need
Stevens?
to look at 170. And I'm taking this shortly. If the court looks at the last part of paragraph 172, 689 of the report. There's a reference which I think occurs elsewhere in Lord Stevens' judgment. Referring to the President's guidance, last third, just below letter G of 172. In any event, the guidance primarily envisages children's home will become registered so that a criminal offence will no longer be committed by others. The judgment proceeds on the basis that the criminal offence has been committed by the homeowner who hasn't registered, not by the local authority and not by the court. And that is repeated at 174.
Yes. And 173.
And again, same sentiment about the criminal offence being committed by others. This last part of 176. And then I do submit that Lady Arden actually fits with what we have seen coming from Lord Stevens and Lady Black. It goes a stage further, but it is consistent with it. And the court will see that at the beginning of 179, he says, I have had difficulty with the limit of the inherent jurisdiction of the court in this case, as opposed to the exercise of the jurisdiction and circumstances of this case. So in this judgment, I set out my additional reasons for agreeing with the judgments of Lady Black and Lord Stevens. Concern arises from the fact that Section 11 creates a criminal offence, which he sets out Section 11. And 182 refers to the Secretary of State submissions about our regulations. Read the paragraph cited against a later point made in Secretary of State submissions that Parliament has now made a statutory instrument which, as of September 2021, prohibits local authorities in England from placing children under 16 in an unregistered home. Proceed on the basis the Secretary of State is not asking the court to exercise its jurisdiction in this appeal to authorise the placement of a child under that age in an unregistered home. And then 184, the reason why Parliament required registration are obvious. The child requires the protection of the statutory scheme for he or she is deprived of their liberty. As I see it, it is for Parliament to decide on any appropriate defence or exception to Section 11 of the 2000 Act. And then 190. Dealing in a passage dealing generally with the limits on the inherent jurisdiction.
189.
190.
Yes, but before that, 189. That leads into 190.
Right. Yes, indeed. And there's a quotation from, I think it's Bromley, the italic heading, the de jure limits, which does include the third line, there is no inherent power to make orders prohibited by statute, as for example committing children into local authority care, etc. And then 192. Conclusion, my judgment, Section 11 had criminalised the use of unregistered homes. The court could not have exercised its inherent jurisdiction, as we ruled out on Bromley's text as well.
Well, you particularly rely on that.
Yes. I mean, obviously, I have to say, it's consistent with Lady Black and Lord Stevens. There's only one Lady Harden, if I can put it like that. But it is going to the heart of the problem.
Well, are you saying, going on, that there is now a clear legislative intent to remove the court's inherent jurisdiction in cases of absolute necessity? We look at the words Lady Arden uses in the second sentence of 192.
No, I don't think I do say that.
Are you saying that the court is now the object of the prohibition?
Yes.
The court is now...
It's got to be, and the consequence is that it has to be satisfied of an overriding absolute necessity to make an order because of the demands of Articles 2 and 3.
It's the local authority that's the object of the prohibition.
Yes. I've tried to deal. I mean, obviously there's a submission to be made against me, which undoubtedly will be made, that the court's dealing with deprivation of liberty and the local authority's dealing with the placement. But your lordship has my submission on that, which is that's a fundamental, leaves the local authority in a hopeless position, actually. You don't have the power to do it. The fact that the court can authorise the deprivation of liberty doesn't deal with the necessary condition precedent of the making of a lawful placement. And then finally, I think here's just before lunch.
Yes.
Paragraph 196 has one of the references to the human rights cases dealing with the absence of resources.
Yeah.
There's a similar reference in Judge's President's Guidance judgment. I think I've already said. What are those I think are my submissions, or there may be things we want to think about and come back and reply, but those are my submissions for now, unless there's something else in which I can help.
It's very helpful indeed, and we've taxed you about all these matters because it's plainly not easy. And I'm very grateful to you and to Mr. Barnes, who's the architect of I think a lot of what's been said. So
Absolutely.
appreciate it. Anything?
He hasn't touched on his grounds.
Yes, and I think it's been implicit in what you've said how these submissions tie in with the grounds of appeal. I don't know if you want to formally do that, and in particular, ground 2, I don't think we've expressly gone to.
I think I do want to say that both ground 1 and 2 run hand in hand, and actually, as I've been thinking about the case, because it's the nature of because there is on our construction a statutory prohibition, one may be more naturally in the territory of the exercise of the inherent jurisdiction not being available, where it cuts impermissibly across the statutory scheme. And I mean that fits in very well with what Lady Arden was saying. 190, court must respect parliamentary sovereignty and the separation of powers. And so you find an express prohibition taken on board for an understandable policy reason, and that's your starting point when it comes to the exercise of the inherent jurisdiction.
Anything else?
Yeah, thank you.
Nothing else? No, thank you very much, Mr. Travel. So it would now be you, Miss Cavan. I don't know whether you want to. We've covered a lot of ground this morning, and I must say the submissions are now even more clear than they were on paper. I don't know whether you would rather take stock now by having the short adjournment at an earlier stage, or begin your submissions now and break at the usual time.
Well, my lord, I'm in the court's hands, but it's certainly the case that the first part of my argument is just to reframe the limits of the statutory scheme, and it may be that well, it'll be ambitious, but I'll have a go at trying to do that prior to lunch. If that assists you, it's not a...
Good.
I'm grateful. Thank you. Well, my lords, my lady, I must make one correction on a factual point. In the Tameside case, it's just for the purposes of the judgment, the paragraph 10 of our skeleton argument, which you will find in the core bundle at C47, or the electronic version, my lady, at 181. The placement that the Tameside child was ultimately moved to after the relevant judgment was in fact at that stage registered as a children's home. It's very minor, just wish to correct it for the record. I will address 6 issues, but in order to keep to the ambition of dealing with the first, I'll just read out the first and I'll take you through the other 6, the other 4 after the lunch adjournment. But the first one is just to look at local authority duties and powers under the Domestic and Convention, or relevant to Child C case. That is not as wide as it might initially appear. Essentially, for these purposes, one's looking at section 22.3 A and B of the Children Act, section 20 and 22A, which are the duties to provide accommodation, the former being the duties to safeguard and promote the child's welfare.
Sorry, can you read those section numbers out?
Section 22.3 A and B.
22.3.
Subsection 3.
Right,
A and B, forgive me. And you can extend that with 22A. because that is, 22 capital A, because that is the duty to safeguard and promote the child's welfare, which then is extended to a particular duty in relation to education under 22 capital A. The next points are 20 and 22A, which of course are the duties to provide accommodation to first voluntarily accommodated children and the second to children under a care order. The third is the sufficiency duty at 22G. And then, of course, the Human Rights Act at Section 6 and 3. It's those duties which are under domestic law, which I'm going to come, if I may, just briefly, just to frame, because it's right to say that some of those are expressed in rather absolute terms without exceptions, and some are expressed in terms which have room for, or certainly language which is not so absolute. So, for example, Section 20 and 22A, you will find these at the authorities bundle at A56 and A64. But let's just take Section 20, if I may, at A56.
A minute. Yes.
Thank you. One can see, or my lords, my lady can see there, that the duty is without an exception in truth once it's engaged. The section looks to where it's engaged and the circumstances in which the duty under Section 20 is engaged. But it's right to say that that duty is not limited, for example, by the availability of provision of accommodation, which I'm going to come to when I turn in a moment to the sufficiency duty. It's not limited by that. It's not that we can provide, or we shall provide accommodation where accommodation is available. That is it's a duty that doesn't forgive of any limitations on accommodation. And for D, CK, of course, the duty to accommodate was engaged upon her discharge from section under the Mental Health Act in late August. The local authority could not abrogate that duty to her. She must be placed in accommodation. Section 22A is of similar effect. You'll find that over at 64. I won't repeat it, but the point's the same. One will not find a caveat or an exception for availability of suitable accommodation or other exceptions. Once a child is under a care order, there is a duty to accommodate. Not a duty to accommodate particular accommodation, but a duty to accommodate absolutely. If I may, Section 22(3)(a), which of course is the duty to safeguard and promote a child's welfare, which, forgive me for taking you backwards and forwards, is at A60 of the bundle. There is, in our respect for submission, only one exception to that. Whilst there is, of course, delineation and explanation of the duty, it's right to say that subsection 6 of that page, if you turn over, my lords and my lady, to A61, you'll find that the only circumstance in which a local authority it does not have to act consistently with their duties under that section is if a local authority needs to protect members of the public from serious injury, to exercise their powers in respect of a child whom they're looking after in a manner that may not be consistent with those duties. So if one has to protect the public, then one might have to act in a circumstance which does not safeguard or promote the child's welfare, for example. One might have to prioritise that, and that would provide an exception. But CK's behaviours here were self-injurious. So the primary issue was not harm to the public or to others. So the duty to safeguard and promote her welfare was engaged and remains so, and it forgives, in our respect, for submission of no exceptions. Turning then, if we may, to 22C5, which my lords and my lady will find at A68, and electronic bundle, my lady, 70. in short, where a child cannot be placed with a parent or a person with, or the whole, with PR or a holder of a child arrangements order prior to the child's accommodation, then the local authority is under a duty to place the child, and importantly we submit, if you look at subsection 5, in the placement which is, in their opinion, the most appropriate placement, and I underline this word, available. Where the most appropriate placement is not available, for example, an approved secure accommodation bed, which there was a point at which CK would have needed that and couldn't have it because it was unavailable, then the subsection allows the local authority to place the child in the most appropriate available placement.
In their opinion.
In their opinion. I'm grateful, my lady. The guiding principles for the choice of placement under section 22C5 are that they must be first most appropriate and second available. The choice of the most appropriate placement is governed by sections, of course, subsections 7 and 8, which start in determining the most available placement. And they, of course, set out, of course, that they're all subject to the other duties of the local authority, but go through, for example, the hierarchy of priorities looking towards kinship or familial care. These duties are specific to the child. They must look at all the circumstances of the child's case, alongside, of course, other welfare priorities, and you'll find that in subsection 7b. And of course, we're concerned here with subsection 7, so if we may just, subsection 6, go back a page. Subsection 6, of course, is the definition of the word placement for the purposes of subsection 5. What subsection 5 does not provide for is where the placement's referred to for the purposes of subsection 5, namely those set out in the list under subsection 6, are not available. So once we reach the point where it's unavailable, it's not provided for within section 20.
Do you say that 6 is a closed list?
This is the issue. In my respectful submission, this is where one reaches the limit of the Children Act. Because in truth, where the most appropriate placement is either the placement's inappropriate or is the most appropriate placement is unavailable, or indeed any placement which is within the regulatory scheme is unavailable, what subsection 5 of 22C does not do is address the situation of unavailability.
But it limits, subsection 6 limits what is a placement for the purposes of subsection 5. That's your problem.
Yes.
And that isn't addressed by availability. That's nothing to do with availability.
Yes. But where, if all the placements in subsection 6 are unavailable,
well, then it's not a placement. Then it's something else. It's a B&B. And that's not allowed, according to the argument against you.
well, it's not necessarily a bit, that a B&B would be unregulated,
Yes.
but something that falls within to be considered under subsection C, but then falls outside of subsection C of subsection 6 because it's a children's home, though unregistered.
Yes, you need to address that argument
Yes,
rather than availability.
Yes, forgive me, I was building a point, but I'll move on because it's not, because of time, perhaps if I just finish the sufficiency point, and I'll build that argument in due course after lunch. Perhaps I ought to have foreshadowed the list at the beginning. It's my error. The sufficiency duty then at 22G, my lady and my lords will find at A72 of the authorities bundle. the general duty of a local authority to take steps that secure, so far as reasonably practicable, the outcome, namely, and that outcome set out in subsection 2, that the local authority are able to provide for the children mentioned in subsection 3. And of course, it must be in the local authority's area and meet the needs of those children. But unlike the duty to accommodate, and unlike the duty to safeguard and promote the child's welfare, the general duty to secure sufficient accommodation is not expressed in absolute terms, insofar as is reasonably practicable. Accommodation provided is anticipated in this accommodation provided is anticipated in this section is set out in subsection 5. So we need to, as far as is reasonably practical within the aims of the objective, we need to try and ensure we have sufficient local authority foster parents and children's home which are registered. Drafted into the sufficiency duty in our respect to submission is a recognition that it will not always be possible or practicable to have sufficient accommodation to meet the needs of every child who falls under subsection 3 within your area. And this anticipates scenarios where it is not reasonably practical to have accommodation meeting the needs of every particular child, including a child such as D.
In the area?
In the,
or at all, you say?
In truth, it's difficult to see how a local authority, subsection 2, which refers to the area, the outcome is only part of the outcome. So if a local authority could, outside its area, have sufficient children's homes that they still are in control of, and this, for example, comes where some local authorities have secure accommodation provision where they are technically the provider of that, though it goes into the general pool, it may be out of area, but nevertheless it's part of their sufficiency duty. So I don't say that it's only limited to their area, I do say that that's part of the objective. But nevertheless, we submit the drafting of the Children Act itself contemplates both in section 22G1 and 22C5 that sufficient placements may not be available. But nevertheless, the drafters maintained that the local authority duties to provide the children with accommodation when the accommodation duty arises and to safeguard and promote their welfare interests don't forgive of those sorts of exceptions or any exceptions.
But you can't use section 22G to qualify section 22C6. You can't say that they've got a duty to provide sufficient accommodation, but of course they may not have sufficient accommodation, and therefore that in some way is an exception to section 22C, if that's what you were submitting. That doesn't seem to follow.
I don't submit that it qualifies it. What I submit is, within those two sections, even looked at separate, subsections looked at separately, you have recognitions that there are certain limits to what can be done so far as reasonably practical.
But that relates, again, it's the duty is to provide accommodation within the area and that meet the needs of the children.
Yeah. But our duty to accommodate the child is not...
You've got to put it, you've got a young person, you've got to put them somewhere. You've got a duty to accommodate them somewhere.
Regardless of those 2 points.
Right.
And importantly, for the purposes of linking in then to the rationale of the judgment of Lady Black in UT and then feeding through to the other 2 judgments, the duty to safeguard and promote their welfare. And it's that, in our respect submission, why, for example, Clark, Morrison and Hall refer to those duties as primary duties, because to some extent those duties are the theme throughout the Act. They have a central place.
So is it going to be your submission that the duty under section 22(3) is the overarching duty, and that where a placement that is constrained by 22C6 does not safeguard and promote the child's welfare, then your overriding obligation is to use the inherent is to use whatever is available to you, and that would include the inherent Is that what you're saying?
Slightly more finesse than that, but
Sure it
in truth, forgive me,
No.
my lord, it's essentially that that scenario is not covered by section 22(6). Sorry, 22(c)(6). That the scenario in which a child needs secure accommodation, essentially of the second type within RET, detained therefore in accommodation, and its needs cannot be met in the available accommodation, then that child falls outside the statutory scheme.
Where you have, on the one hand, as you say we have here, I don't think this is a dispute, what appears to be a tightening of the regulations as to authorise, as to lawful placements. We'll come back to that later. But say we have that. At the same time as a failure by government generally to make adequate provision, then the consequence is that the overriding duty under 22(3) obliges the local authorities to look elsewhere. Is that what you're saying?
Yes, and it also...
Probably with more finesse than
my lord, no, precisely what I'm saying, but also, my lord, it coincides with the operative duties under the Convention, because, of course, an operational duty under Article 2 and 3, the objective and the outcome to those is to safeguard those children where that is engaged. And you have a coincidence of objective under the domestic legislation. I bring this back to whether, in fact, the domestic scheme does provide safeguards. Forgive me, I ought to perhaps have foreshadowed where I was going in the list at the beginning, but is that a convenient moment? That does complete, for the main part, my point, and I'll pick it up after the lunch and adjournment if that. But I might just refer you to, forgive me, just let me check this necessary. Yes, this point is picked up in truth by Lady Black in UT at paragraph 145, where she in fact identifies that the conundrum, you'll find this at B73 of the authority.
Well, this is the point I put to Mr. Pratt.
It is precisely, my lord.
The last two sentences.
Which is why I hesitated before wasting your time with it potentially before the lunch and adjournment, because you have it. But it's the point my lord put that she reads in the middle of paragraph 145 at F. How can a local authority fulfil these duties in the problematic cases with which we are concerned they cannot obtain authorisation from the High Court to place the children in the only placement that is available, with the ability to impose restrictions as on required on the child's liberty, and it's also part of why the judge in the court below, the Honourable Miss Justin MacDonald, picks up the centrality of the safeguarding duty and that promote the welfare of the children.
So is your submission that in addition to the inherent jurisdiction being used to authorise the deprivation of liberty, where the accommodation that's been found falls outside the statutory definition of placement, for example, an unregistered children's home, yes, the court actually goes further and authorises the placement in the unregistered children's home?
I say that it provides inherent procedural protections and safeguards through the inherent jurisdiction. I don't go as far as to say it authorises the placement.
Right.
Forgive me, I'm trying to be short prior to lunch, if I might develop that after.
Yes, certainly.
Forgive me.
That was a precisely convenient moment when you first mentioned it. It's now 1 minute after a convenient moment.
Would now be a convenient time to hand up documents.
Yeah, certainly.
I'm very grateful to my friend Miss Clement, who during the break got messages across 3 copies of the explanatory memorandum and 3 copies of the secure accommodation regulations, and I believe we've got other copies for people in court.
Well, the secure accommodation regulations are in the bundle, but you've been given the original version of the regulations. They've been amended numerous times since 1991. I've given you a copy of the amended version.
Secure accommodation regulations.
Yes, my lord, that's right.
Great, thank you. Thank you very much.
you.
Good. Shall we come back at 2:05? Thank you.
All right.
Apologise, throwing things at you. Fine.